3 years ago, I did not know what ERISA reimbursement was. Honest truth. And it sort of sounded boring to me. But a little bit of background. Until 2006, this was not an issue. And I will say, to show you how that's so removed from me, I did ask 2 or 3 lawyers here today, including your president, do I need to explain what ERISA reimbursement is to the group in the room? And they just laughed out loud. They said, you don't need to explain anything about it. It affects everybody in the room. So until 2006, though, it really wasn't an issue, until the U.S. Supreme Court decided a case called Sereboff. For those of you not familiar with the facts, just big picture, the plaintiffs had recovered $250,000 in a tort suit. The ERISA insurer sought the $75,000 it had spent on the plaintiff's medical care, but minus whatever the costs and attorney's fees were to recover that $75,000. It wasn't seeking anything more than what it had spent minus the costs and attorney's fees from a plaintiff who had recovered 10 times that amount. There was also no money involved from uninsured motorist coverage or underinsured motorist coverage or any other insurance the plaintiff had paid premiums for. This was a straightforward case. And the issue was the insurer was suing to get that $75,000 minus costs and attorney's fees back. And the issue was, could it sue for that? That was the only issue. And the Supreme Court said, yes, it can sue for that. Section 502A3 of ERISA says you can sue for, quote, appropriate equitable relief. And if you look at the law of equity, go back into our old history books from the 1800s, there is something called an equitable lien by agreement, where you're suing for a specific portion of a specific set-aside fund, and this is basically like that. And since all they're suing for is that a portion of the set-aside of the full tort recovery, we're going to say you can sue for it. And the plaintiffs said, well, but wait a minute. They are seeking to get 100% of their medical damages, all they spent on medical treatment, when we didn't receive 100% of all of the Sereboff's damages. We weren't made whole, so they shouldn't be able to get 100% of their medical damages. And the Supreme Court said, well, that's an interesting argument. That goes, we said it was equitable, the phrase in the statute is appropriate equitable relief. All we have held is that they can sue for appropriate equitable relief. This is equitable relief. What's appropriate, we're not addressing because you didn't raise it below. Now go back and argue about appropriate. We're not deciding that. That is an issue to be decided in a different case in another day. That different case is U.S. Airways versus McCutcheon. The different day is November 27th. That's when we will be arguing the case. To be clear, I will not be arguing the case, and I did not argue it below. To show you sort of what a difference it can make, we hired a young fellow coming out of, he actually had worked at Williams & Connolly for 4 years, but really wanted to be a public interest lawyer. And he joined us 2 years ago at a fellowship funded by 2 of our members, joined us. When none of us knew what ERISA reimbursement was, we said, go figure this out. He looked at it, talked with us and the more senior attorneys, how we got here. So Matt Wessler is the lawyer who argued both of these cases, one in the Third Circuit, one in the Ninth Circuit, and will now be arguing it in the Supreme Court. But how we got here is after Sereboff, the insurers started to write contractual provisions in all of their agreements, saying that they got 100% of what they had spent first, before the clients got a penny, and before the lawyers, even the lawyers who'd gotten the medical damages reimbursed, got a penny. They said they got it all first. They would assert a lien by sending it to you, and if you didn't agree to pay it, they'd sue. And they would sue not only the client, but sue the lawyer for all the money. And they won in circuit after circuit. They won in the 5th, 6th, 8th, 11th, and D.C. circuits. right? 100% everything, the lawyers get nothing, the clients get nothing. And then Mike Nelson here got threatened with the same kind of suit. And he called Mike Withy and Paul Strittmatter, and they called us. And we said, this isn't right. This is an outrage. Let's get on it. And so we got Matt on it. We got Leslie Bruckner, another senior lawyer who's successfully argued a case in the U.S. Supreme Court, and me involved in it. And we came up with their help and with the team's help with what we thought was the right way to approach this. Now, so you understand, for the most part, when all the plaintiffs argued in the other circuits and they lost, what they were arguing was they can't get a penny, the insurers can't get a penny until we're made whole. And the circuits kind of looked at that and said, you know, it seems a little greedy. It's like, wait a minute, you have to get 100% of your damages before they can get anything for all of the medical things they paid? And I think the atmospherics had a big impact on why the plaintiffs lost. And we came in and said, we're going to argue for something different. We're going to argue for proportionality. Because we're going to come in and say, if we got 50% of our damages, then we're happy to pay the insurer 50% of the medical it paid for, minus costs and attorney's fees, just like in Sereboff. And they're the greedy ones. They're the ones who are insisting we have to get 100% before anybody else can get any, including the lawyer. We took it up to the Third Circuit, and the Third Circuit quite strikingly said in U.S. Airways versus McCutcheon, said, we've looked at these other circuits. We think they're wrong. Now, they haven't heard the argument we've heard before, and we think maybe if they did, they'd say they're wrong, but we think they're wrong, and adopted exactly the argument we were making. And then in the Ninth Circuit, in CGI versus Rose, the Ninth Circuit said, well, we've looked at it. There's a clear split in the circuits. A bunch say one thing, and the Third Circuit says the other. We think the Third Circuit's right. That was on a Friday. On Monday, the U.S. Supreme Court granted cert, which we weren't surprised by. There was as clear a split in the circuits as you could make. On the other hand, it wasn't like we were real happy about it, given that it's the U.S. Supreme Court right now. So let me sort of tell you where we are. The briefing is now taking place. The other side has filed their briefs. The U.S. government has filed its amicus brief, and our briefs are due in a couple of weeks. The oral argument is set for November 27th, but there's already been a really important development in the case. The U.S. government's amicus brief takes the position. They had already taken the position in Sereboff. They had dropped a footnote saying the insurers were right. And they were entitled to get everything right first, although the U.S. Supreme Court did not reach the issue. And so we went in to meet with the SG's office, Solicitor General's office, and they said, well, we already took a position. We don't hardly ever reverse our position. And by the time we were all done, they have now taken the position. They're not going to change their view about what the plaintiff gets, but they have changed their position on the attorneys, and that the insurers should not be able to get anything from the attorneys. In fact, the insurers should have to give the attorneys their portion of what they got to get the money that the insurers are claiming. So it's going to be a fascinating argument in the Supreme Court, because the Solicitor General is trying to split the baby. We're saying appropriate equitable relief under this statute is they get, if it's 50% of the recovery, they get 50% of their medical damages minus costs and attorney's fees. They're saying appropriate equitable relief is enforce the contract as written, period, end of discussion. And they're going to say, and the Solicitor General is right on half of it and wrong on the other, and we're going to say the Solicitor General is right on the other half of it and wrong on the other. So it's going to be quite a fascinating argument. But I want to make sure you know not only that that is taking place, but we've learned a real lesson here that is really important for what you guys do every day in your cases. Make sure you get the actual documents. Do not believe their representations of what the documents say. It turns out Mr. McCutcheon and their U.S. Supreme Court brief quotes this. The summary plan description says that the ERISA reimbursement clause in the insurance contract says, and they put in specific language, that we get 100% of all of the money that the plaintiff gets from third parties, including from insurance the plaintiff has purchased himself. Now, this is important because the plaintiff got $10,000 from the guy who hit him and $100,000 from an uninsured motorist coverage, underinsured motorist coverage, okay? It turns out that extra little clause, including from the insurance that the plaintiff has bought, isn't actually in the insurance plan. It is only in the summary plan description. And they're now telling the U.S. Supreme Court this is what the agreement says. So obviously we will use that, right? But for the case to be able to get to the Supreme Court and nobody to know that is because they've been seeking it for years and the insurer never provided it. So I'm telling you, in your own cases, if you had gotten something like that at the trial case, you'd never get much further than that. Fine. Take the full $10,000. We'll just keep the $100,000. You wouldn't have a big argument. So I will say that's just one example of the kind of work that public justice does. We are obviously very eager to see how it happens. I know a lot of people say, well, don't you expect the usual 5-4 split and we're going to lose? You know, you're suing a corporation. And the truth is no. Now, maybe it's that I'm not that cynical yet, but I think it is also because when you read these cases, it goes down, they keep going back to historical equitable principles. Sereboff basically even says, look, you may think this difference between law and equity we learned in law school, you know, doesn't matter and it's boring and all that sort of stuff, but Congress said appropriate equitable relief. The question is, what did it mean there? And it's citing treatises from the 1800s, which Matt Wessler, bless him, spent weeks in the library researching. And so we actually think there's a significant chance in this case. But we also think you just got to keep fighting.